This episode of AHLA Speaking of Health Law is brought to you by AHLA members and donors like you. For more information, visit AmericanHealthLaw.org.
Hello, thanks for joining us on AHLA's Speaking of Health Law podcast. My name is Herb Allen. I am the chair of the Antitrust Practice Group at AHLA and partner at Honigman in Washington, D.C. And I'm joined by one of my colleagues in the AHLA Antitrust Practice Group, Jeff Oliver, who is a partner at Baker Botts and has a lot of experience in healthcare antitrust law. So welcome, Jeff. Excited to be here and to talk to you about some of the recent developments under the Trump administration in healthcare antitrust.
Yeah, thanks, Herb. Appreciate the invite to be on the podcast. I'm looking forward to the discussion.
I think we're something like 6 or 7 months into the new administration, and I think we're now starting to see some trends that we can sort of draw some conclusions from, and hopefully give some advice to our healthcare clients about sort of how to interact with the agencies and what they might expect, when they have a transaction or some kind of an investigation. So let's just start off, Jeff, with a discussion of who the new antitrust team is within the Trump administration. I think, one of the really interesting points about this, I think, is how serious all of the antitrust enforcers are. They bring, deep experience at the agencies. Several of them have state antitrust enforcement experience. FTC Chair Andrew Ferguson was the Virginia Solicitor General. Melissa Holyoke was the Utah Solicitor General and oversaw antitrust enforcement in the state of Utah. So I think, really, for folks that maybe you're seeing podcasters or influencers in other parts of the Trump administration at a high level within antitrust enforcement, it's really are serious people who have deep experience.
Yeah, I think that's a great point, Herb. I mean, particularly, I think at DOJ, Gail Slater, who's the AAG over antitrust, I think she, at least in this round of nominees for positions in the administration, Gail had either the highest or the second highest approval when it came to the vote in the Senate. She's one who has just undeniable credibility in antitrust, a long background in antitrust, serving on both sides. She was an attorney advisor to a Democrat commissioner at the FTC before she became J.D. Vance's antitrust advisor during the election. And it does seem like the Trump team, as they came into office, put a lot of effort into picking credible and, like you put it, serious candidates for these positions.
Yep. Well, I think the other point about these people, and this came through on in Gail Slater's confirmation testimony and in just public statements that have been made since they've taken office, is that all of these new enforcers at the FTC and DOJ are very interested in healthcare, and they see that as an area where really there should be robust enforcement. And I think we're starting to see that in the cases. But I'll just quote Chair Ferguson here. This is something that he said recently is. He said, protecting health competition in healthcare markets will be one of the highest priorities of the Trump-Vance FTC. And Gail Slater echoed that in her confirmation hearing, saying that healthcare is one of the industries and sectors that impact the day-to-day lives of the American people more than any other. And so we're going to continue to see scrutiny, heightened scrutiny in that area. And
yeah, you're right. Sorry, Herb. Just one thought I had on that topic. I mean, it's still some of the case, for example, in certain industries that no leader or even politician gets in trouble when they subject a particular industry to aggressive scrutiny. And, for a long time, energy has held that position where, yeah, there's maybe a pro-business slant on one side or the other, but both sides feel entirely comfortable, calling for significant scrutiny, just given the strategic nature of the industry. And then you've seen that also, a kind of consensus around big tech as an industry that both sides just seem to agree, demands close scrutiny, whether that's right or wrong. I'll reserve judgment. But healthcare, I think we can now say is squarely in that same bucket, where both sides, feel entirely liberated in terms of their constituencies supporting an aggressive approach to antitrust.
Mm-hmm. Yeah, I totally agree. And I think we're seeing that in the cases that they're bringing. We'll talk about some of those, but a number of them are in healthcare. So yeah, there's continuity, there's bipartisanship in terms of wanting to focus on enforcement in healthcare. So let's talk about some of the other kinds of continuity that I think we're seeing between the Trump and Biden administration, which again may be surprising to some folks who would have thought that there would be just sort of a whole new approach. And Trump has talked about wanting to really deregulate the economy, and he's dismantled agencies, CFPB and others that are charged with enforcement. But again, we're not seeing that in antitrust, and in fact, there's kind of some really surprising continuity in terms of policies and regulations that the Trump team has endorsed. And let me just talk about the first one, and we can discuss a little bit. But it's the Biden era 2023 merger guidelines. And so, just to give a quick intro on what that is, merger guidelines are a policy document that the agencies promulgate in order to just really at a very high level describe the analytical tools that the agencies use when evaluating mergers under the antitrust laws. And the Biden 2023 merger guidelines, I think, were really pro-enforcement in a number of ways. They lowered market share thresholds for finding anti-competitive conduct. So, for example, under the new merger guidelines, transactions that result in a 30% share can be presumed to be anti-competitive. And that's a really significant expansion of what is presumed to be anti-competitive, because I think under the prior guidelines, a 30% share would have been presumed lawful in most cases, right? So right. Significant change. Also, the new merger guidelines tighten up what you have to show to prove efficiencies. That's sort of a way to defend a merger by showing, that there'll be sort of pro-competitive benefits from a transaction. That's tightened up. And then there's also a greater focus on potential competition and innovation markets under the new guidelines. This was an area where I thought, maybe we'd see a withdrawal of the Biden era guidelines, but not the case. And in fact, Ferguson said when he took office on X, he posts a lot on X. He said on X, by and large, the 2023 merger guidelines are a restatement of prior iterations of the guidelines and a reflection of what can be found in the case law. There's good reason to retain them. They're not perfect, he says, but if revisions become necessary, they will consider them down the road through an iterative and transparent revision process.
Yeah, I think it was one of the more interesting dynamics in the transition from the prior administration to this one is this question of were they going to keep these guidelines. The background on them is that they were the 2023 guidelines were released in a draft form a couple of years ago for comment, and the initial draft form of the guidelines were so aggressive when it came to applying, Section 7 of the Clayton Act to mergers that that there was just an almost nuclear response to them from all sides. A lot of aggressive-minded economists and advocates found lots to hate in the guidelines, and there did just seem to be a severe animus toward deals sort of baked into the draft. Some of that stayed. Fortunately, due to that reaction, the final version, the temperature came down quite a bit, at least rhetorically, in the guidelines. A lot of more aggressive posture stayed in, like the 30% threshold that you mentioned. It's probably worth mentioning that the guidelines are not law, and despite Ferguson's claim that it's all supported by case law, that 30% is not supported by case law. I can't remember. I'm sure it's happened, but it's very rare that a court would support enforcement action against a deal where the combined shares end up at 30%. It's still a very low threshold. The FTC knows that. I don't think I've seen them bring a suit on a transaction at 30%. Nevertheless, it's still a good indicator of when they will issue a second request and when you have a long investigation on your hands. I'll point out just one example of impact and likely influence of the new guidelines. Last month, the FTC sued to block a deal between Edwards and Genevalve. These are two companies that make healthcare devices, essentially, medical devices. In this case, particular, quite complicated and innovative devices to treat a kind of rare heart condition. And neither of the products at issue were actually outside of clinical trials yet. They weren't being sold. They were in R&D phase, testing somewhat, but still a ways away from market. And that's notable because it's rare that the agencies bring a pure pipeline enforcement action against a deal that is focused solely on where the antitrust issue is focused solely on a pure pipeline product, meaning a product in development. And a kind of innovation market. They don't use that word in the complaint on this deal, innovation, but that's what it is. And it's the effects are all around kind of what this will do to future competition that doesn't quite exist yet because neither product's being sold. They're the only two companies that are making the product, or at least that have the product in development. And it's also that's the relation of that to the guidelines is that this version of the guidelines spent much more time than its predecessors on this question of how mergers and consolidation can impact the incentive to innovate. And they also explicitly call out a pipeline type market where products that are in development can be the subject of a kind of narrowly defined product market, which the agency under prior leadership had somewhat shied away from. There's a very analogous example in 2004 where two companies who were also creating medical devices, Genzyme and Novozyme, they were up for merger and did end up merging. But the merger was subject to an extended investigation. And an administration at that point, which was also Republican-led, passed on the deal with some commentary around, lingering questions about how mergers impact innovation. In other words, Tim Muris, who was leading at the time, indicated that he had some doubts about whether you can honestly say consolidation impacts the incentive to innovate. That's a question that the current guidelines put to bed, essentially, or at least sort of present as having been settled, in the affirmative, that the consolidation does negatively impact the incentive to innovate. And I think you could argue that this enforcement effort on the Edwards-Genevalve transaction is a result of that added sort of traction on these innovation market and pipeline market questions.
Yeah, I think agree with all of what you just said. I think the other point I would make is that these are hard cases to win often. And they're hard because you have to show, a substantial likelihood that these products that are still in, regulatory review, that maybe still in clinical trials, that they're actually that there's a good likelihood that they would ultimately reach the market, right?
Yeah. No, that's
right. And so the defendants can point out all the challenges that are still still in the way of approval and of commercialization, and enforcers have to make a strong case that this is not just sort of hypothetical products that may or may not actually reach the market, but they really are likely to do so.
Yeah.
So I would say this is the Biden, the Trump antitrust team bringing a hard case. What it looks like to me.
Yeah, an indication that, again, healthcare, they're willing to run some risks. There's, as you're saying, significant litigation risk in bringing this type of enforcement action, and a purely Republican-led FTC. I mean, there are no Democrats currently on the commission, although that changes week to week. Sometimes we may talk about that, but that the Republicans unanimously were willing to run this risk with this enforcement action.
Yeah. Well, let's talk a little about HSR. So the HSR Act, folks who do M&A deals will know what that is. It's a statute that requires notification to FTC and DOJ for transactions that are above a certain size threshold. That's currently $126.4 million. So it has to be a sizable transaction to be reportable under the HSR Act. And like the process that you described with the merger guidelines, the HSR rules for a number of years under the Biden administration were undergoing kind of draft revisions. And so what happened at the end of the Biden administration, really in the closing days, is that they released new HSR rules that pretty dramatically expanded the information that merging parties have to provide to DOJ and FTC under the HSR Act. The agency's own estimate in terms of the added burden on parties is 68 hours of additional time per filer, so a substantial amount of additional work. And especially in deals with overlaps, which may not be overlaps in the same market, but if you have an overlap in the same industry code, under these new rules, you have to supply a lot more information about those overlaps, about your top customers, about supply relationships, and it really can be a significant lift, which we're seeing with our clients. But again, this is an area where I think you might have expected a Trump FTC and DOJ might have said, you know what, guys, this is more than we need. The old form worked. Let's revert back to that. But we didn't see that, right? We didn't see that. The Trump FTC and DOJ have said that they are going to continue, and they are continuing to use the new form. Another Ferguson ex post, which I'll read really quickly here. He describes the HSR form, the new form, with all of that it requires and all the additional burden. He describes it as long overdue. Explaining that the new rules ensure that parties provide appropriate information so law enforcement can fulfill Congress's mandate and prevent unlawful deals from slipping through the cracks. So another area of perhaps unexpected continuity between Trump and Biden.
Yeah, this one really surprised me. I mean, there's explanations, of course. I think to some degree the new they weren't new commissioners at the time, but under the new leadership in the Oval Office, they had sort of tied their hands because they had already pre-election approved sort of the change after significant and heated, I think, negotiations over what would be included in the new HSR rules. And I think they had agreed to sign on to the new rules after, Lena Khan and the Democrats had agreed to certain compromises on what the new rules would entail. And so they were on record already having signed up to support the new rules. I think it's difficult to overstate for folks on the line who have not yet done for folks who have not yet done a filing under the new HSR rules. It's difficult to overstate how significant the change is and how much more time it takes. Under the old rules, if it was a fire drill, we could probably put a filing together in a matter of days, 2 to 3 days. That wasn't ideal, but it could be done.
Yep.
This, you cannot do that anymore and have a credible filing or a defensible filing. The shortest time that we've been able to condense it to is about 15 days, and that's really tight. There's just a lot more doc review, a lot more thought in terms of how to describe the deal and describing what the deal entails in terms of competitive overlaps, that sort of thing. So you want to build into your purchase agreements and elsewhere some runway to get that HSR ready for filing.
Yeah. I think, the point about what's required now in the narrative responses is important, because under the prior form, you did not have to affirmatively describe in any great detail the overlap. You didn't have to describe the customer categories, the different products and services, and describe them in terms of what are the categories in which the customer views them. Yeah. You could sort of file and forget, right? That was, we sometimes did that on deals, right? You file and forget, and if there were questions, assuming it's not a really sensitive deal where you expected problems, you could triage those as they came in, right? If there were questions, yes, right. Now all of that is sort of, you have to bake that in at the front end.
Yeah, I think that's a really good point and worth emphasizing. What we're finding as we get more experience with the new rules is that on a strategic transaction, meaning a transaction in which there likely is some overlap that you may need to explain to the agency and explain why it's innocuous, you need to understand what arguments you're likely to make about that overlap while you're filling out the HSR form, which I think is your point, Herb, that before you could kind of throw your strategy, your substantive strategy with regard to the deal together at the tail end, and maybe even after you filed. Now, because you're having to make affirmative statements about those competitive overlaps in the filing and describe it in not excruciating detail, but some level of detail, you need to have your strategy not entirely figured out, but at least thought through, such that you're reserving positions and arguments about the overlap when you're just figuring out how to describe it in the filing.
Yep. Well, let's talk about change, right? It hasn't all been continuity. There's some significant changes, some of which I think will be good news to folks listening to this podcast who want to get deals done. Mm-hmm. And the first one I want to talk a little bit about is greater openness to merger remedies. And so what is a merger remedy? I guess there's really two kinds generally. There's behavioral remedies where the agencies impose some specific conditions on the post-closing behavior of the merged entity. But sort of the more common is what we call a structural remedy, where the agencies require usually a divestiture of some part of the business or locations or, perhaps employees. And under the Biden administration, there was a real hostility towards merger remedies writ large. Jonathan Cantor, who was the head of the Antitrust Division under President Biden, said, "I'm concerned that merger remedies, short of blocking a transaction, too often miss the mark." And he says, "In most situations, we should seek a simple injunction to block the transaction." which is another way of saying you can't fix deals that are partially broken. The preference of enforcers should be to block the whole thing.
Yeah.
Right. So we saw many fewer settlements, many fewer consent decrees with divestitures or with behavioral remedies. And I think what we're seeing under the new enforcers is a much greater openness to settlements. And I'll just, before I hand it over to you, Jeff, to give your thoughts, Melissa Holyoke, recently said that the Biden antitrust team had an unjustified hostility towards divestitures. She expressed hope that the FTC would return to what she called normal operations with regard to divestitures. And she said, where a divestiture can successfully preserve lost competition from the merger, the agency should consider it and focus on the potential benefits to innovation from the remainder of the merger. So potentially a big change here. What are you seeing, Jeff?
Yeah, it's certainly the biggest, I think, most significant change from administration to administration. If you look historically, even in the first Trump administration, and that administration was statistically quite aggressive when it came to policing and challenging deals. It was not unusual in that administration and prior to see years in which the agencies combined signed as many as 20 or more consent orders. Just as a point of comparison, under Biden in the last 2 years, I think the DOJ signed 0 consent orders. And before that, the agencies signed 3 or 4 total, and often they only did so when the judge made clear that they were going to lose at trial. And they then went back and said, okay, well, let's talk about remedies so we can avoid a total loss. So it was just almost a non-starter, and certainly toward the end, you just knew that if you had to propose a remedy to get a deal through, that you were going to either have to litigate or be willing to walk away from the transaction to get the transaction done. So to now have the door back swinging again with regard to remedies is a huge change, particularly for anyone who's looking at a strategic transaction that may require divestiture to get done. The risk profile on those deals has gone down significantly because you will potentially then be able to solve the problem without recourse to a second opinion, meaning a judge. You won't be having to convince a judge that your remedy is justified. You can do that likely at the agency. So just in the last 3 months, the FTC and DOJ have signed upwards of 6 consent orders. Significant, again, still not on pace with historical averages, let's say, but getting there, and far and above what they were doing under the last administration. Some of those have been in healthcare, like the United Health Amedisys transaction, or I'll let you talk about that one because I represent United in my practice. But others include the Hewlett Packard Juniper Networks transaction, where they actually sued in January to block the deal. DOJ did, and then just a month ago or two, they signed a consent order to resolve the competitive issues there. That one's controversial. We'll talk a bit more about the controversy in a minute. Others include Omnicom, and let's see, IPG. That one involved advertising and was noteworthy because it was a purely behavioral fix, meaning no divestiture, just parties agreeing to certain behavioral restrictions of things they can and can't do in practice. Those are extremely rare and are likely to stay fairly rare. Both Republicans and Democrats disfavor them. But noteworthy that the Republicans at the FTC were willing to sign a consent order that was purely behavioral. There's a few others. I'll save the details, but it's the number of them, and they all came in a rush between June and July. Was to this private practice practitioner quite refreshing and a relief to see what seems to me a very reasonable approach, which is if you have a transaction that has an issue that's fixable, let's find ways to avoid wasting resources and time and a lot of money on litigating when the outcome of that litigation is not sure for either side. Herb, back to you for your thoughts on it.
Yeah, well, I mean, I think you're right. This is a sea change. It is an opportunity for folks, especially in healthcare M&A deals. You know, a lot of our deals are deals that involve markets all around the country, and you may have no competitive issues in 90% of those markets. But if there's, you know, an overlap in a couple of places, boy, wouldn't it be nice to be able to get that deal through and divest the facilities or the assets in those few markets where there's an overlap. So I think, you know, healthcare, we've got small markets, often local markets, and so you can have a deal that is largely benign, except we're in a few places, and I think it's good to see that we're in a place where there's receptiveness to an approach that lets you get through you know, the majority of the deal. I'll just say on the Amedisys, United Health Amedisys deal, and I won't ask you to comment on this, Jeff, but you know, this really was a significant divestiture. According to the settlement, the DOJ agreed to allow the deal to proceed on the condition that United Health and Amedisys divest 164 home health and hospice locations across 19 states. And I think it was interesting in the press release, you really see the DOJ almost bragging about the fact that they had gotten this settlement. And they say that by the number of facilities, this settlement would secure the largest divestiture of outpatient healthcare services to resolve a merger challenge in history. So, you know, again, I think this is an agency that, you know, not just willing to do divestitures, but, you know, potentially touting them when they get them as part of a merger investigation.
Yeah, and I think that's an interesting point and an important priority at the current DOJ and FTC, which is one, they want to look aggressive. They believe in you know, stringent application of the antitrust laws, I think, genuinely. But they also want to advertise a difference between them and the prior administration across the board, across, you know, virtually every aspect of government, particularly in antitrust, I think, because the prior administration was so aggressive. I was at a talk yesterday where Gail Slater started the talk by saying that she sees antitrust at a significant inflection point. Now, her saying that doesn't mean it's necessarily true, but it does show that she wants everyone to believe that. And I think the way that they've settled on in manifesting or kind of marketing their difference from the Biden administration is in their willingness, largely in their willingness to consider remedies. And it's the easiest way in which they can check both those boxes. They can brag about, you know, the pound of flesh they got out of the merging parties, and that's a win for the agency. They can look tough. And on the flip side, they can also say, look, we're pro-business. We're working with these parties to transactions. We want to see them grow. We want to see them achieve their strategic initiatives, but we want to see it done in a way that's legal. And we're here to enforce the law. So I think you can expect anyone, again, listening who's looking at strategic transactions. I think you can consider those with a strong hope of there at least being a fix available if you need one.
Yep. And I'll just add one other area, you know, where we're seeing less hostility is in the way the enforcers view private equity. So private equity at the end of the Biden administration came under really a lot of attack, right? And not just because of conduct in a couple of specific cases, but what the agency said is that this business model, the private equity business model, has incentives to do things that may lead to problems, market problems, competition problems. And I'll quote Lena Khan here. She spoke at a workshop on private equity and healthcare, very harshly. She was very critical of the private equity industry. She said, short-term, high-risk, low-consequence ownership by private equity can encourage a flip and strip approach. And she also talks about roll-ups, private equity roll-ups, where private equity firms, acquire lots of small participants in a market, and sort of through those small acquisitions get market power over time. And we saw cases being brought with a lot of anti-private equity rhetoric, but now I think we're in a different world, right? I think Chair Ferguson has said very clearly that there's no reason for the commission, for the FTC, to single out private equity for special treatment. The Welch Carson case, Jeff, that you're familiar with, which is the anesthesia case, allegations that Welch Carson, a private equity owner of a national anesthesia practice, that they monopolized anesthesia markets. According to Chair Ferguson, that case was just an ordinary application of Section 7 of the antitrust merger law that applies to serial acquisitions, and he says no reason to single out private equity. So I just add, I think that's another area where folks who may be doing private equity investment in healthcare, less likely that you're going to see the sort of thumb on the scale against your deal just because the owners happen to be private equity investors.
Yeah, I think that's a good point. And certainly one that will be warmly received, I'm sure, by private equity folks in healthcare, who it seems, private equity itself is going through a tough time just in terms of returns on investment and that sort of thing. And so this for them is some relief. I think at least they're not being demonized to the extent they were under the prior administration. Another quick thought on changes and trends and things to think about. I mentioned earlier about the Hewlett-Packard Juniper deal being somewhat controversial. I'll just talk a little bit about what happened there, fallout, what people should think about. The point of contention or controversy there had to do with the parties, I think in this case, Hewlett-Packard's use of lobbyists, Trump-aligned lobbyists and advocates who appeared to have essentially gone over staff's head and made their case either to the DOJ front office, Pam Bondi's office, or maybe even all the way to the White House. And it's all sort of rumor and innuendo with some statements from affected officials. But it does seem apparent that that lobbying effort had an impact on the outcome of that case. It certainly had an impact on a few DOJ authorities who were fired due to insubordination. And the going theory, I think fairly credible, is that those individuals were opposed to the settlement that the DOJ ultimately reached with the parties and tried to block it in whatever, using whatever leverage they could, which proved to be insufficient, and then they were fired. So that's an important thing to keep in mind for any party who's considering that route of sort of like a who approach to antitrust as opposed to leveraging facts and advocacy. Obviously, I'm biased here. I'm a lawyer, not a lobbyist, and for a long time I worried that AI would be taking my job, but maybe it's the lobbyists that are going to take my job. I doubt that, honestly, and just a word of caution on that approach. I can't deny that it can be effective, and maybe particularly so in this administration. It is always consequential, though, for the parties who take that approach. Once you go above staff's head, and particularly if you go above the divisions, the antitrust division's head at the DOJ, particularly, there's going to be significant fallout, as there was here, because arms are going to get twisted at the agency. People are going to be put in extremely uncomfortable positions, and some, as happened here, may lose their jobs. That leaves a very sour taste in among the DOJ staffers, and your brand then at the DOJ takes a pretty significant hit. So if you're a repeat player at the agency, it's worth thinking hard about whether or not you want to pursue a kind of lobbying approach to getting your deal done. It may be effective and it may be the right choice. But it does not come without risk, I would say. And I welcome your thoughts on this, Herb.
Yeah, I mean, it certainly feels like this was sort of the nuclear option in this particular transaction where, staff had already reached a decision about where they wanted to go, and that was to litigation. And, the higher ups at DOJ apparently working with lobbyists, sort of came over the top and, basically instructed them to take a different approach. I do think like when you do the lobbying probably makes a difference, right? I mean, if you're sort of waiting till the very end after staff has reached their decision and you're really trying to get the senior most folks in at the Justice Department to reverse something that has already been decided by staff, that may be a more challenging approach or a more aggressive way to go about it than trying to get influence things earlier on. And I wonder if they did do that.
I think that's a good point. Actually, earlier is better in terms of avoiding the fallout that you saw here. As I said earlier, DOJ had already sued in January to block the deal, and so you're talking 6 months later than when you're already in front of a judge, essentially. You have staff who's extremely committed to whatever theory they're pushing in front of the judge, and the whole division, antitrust division at the agency, obviously now having leveraged all their resources into a litigation posture. There's no quick route out of that without significant disagreement at the division level. And so earlier, I think you're right, Herb, an earlier approach to advocacy where you may be able to avoid all of that division fallout would be better.
Yeah. Should we just quickly go over the non-compete developments? We've had a bunch of them in the last month. Early September, the FTC withdrew its defense of the national non-compete ban that was the rule that was promulgated under the Biden administration, which means that national non-compete ban is basically dead. But at the same time, we have the FTC chairman coming out and saying, Chair Ferguson saying that we're going to continue to aggressively enforce the antitrust laws against non-competes. And in fact, last week, Chair Ferguson issued warning letters, pretty strongly worded warning letters to large healthcare companies. And again, this is specific to healthcare. Interesting that Ferguson decided to do this in healthcare. I think it shows the focus on healthcare. But what he said is available information suggests that many healthcare employers and staffing companies include non-competes that may unreasonably limit employment options for vital roles like nurses, physicians, and other medical professionals. And he calls on healthcare companies to do a comprehensive, careful review of their non-competes to make sure that they're not overbroad. And I'll say one more thing. It seems like he's especially worried about non-competes in rural markets. His letter specifically mentions concern in areas where there may already be a shortage of providers of, healthcare professionals. So interesting developments there.
Yeah, definitely interesting, and particularly as it comes on the heels of them sort of, declining to defend the non-compete rule that the prior administration had put in place and then was challenged in court. And so there's a bit of a conflicting message there. How much do they care about non-competes? But it's clear, at least in healthcare, that they still care quite a bit, and healthcare companies where non-competes are important. and sometimes really quite essential to investing in a new market or building out a new product and practice. There's no doubt that a non-compete allows you to make an investment with a little bit less risk that it's going to be poached from a competitor when they hire your talent. So this is not to say that non-competes cannot be they cannot exist. The boundaries and sort of borders of what's allowable are a bit hazy at the moment, but a non-compete, there is no blanket ban on non-competes anymore. That was a rule that was instituted by the Biden administration, and then, like I said, challenged in court. That blanket ban has gone away, but the concern about the effect of non-competes has not, and so it's worth thinking hard about what do you need, what do you feel comfortable with in a non-compete, and is there a way to dial, if you have a lot of them, to dial them back in a way that reduces your risk of an extended investigation at the agency?
Yeah, I think, in terms of what the substantive law is that will be applied here, this morning letter does not actually contain any new law. It doesn't contain any new statement of when enforcement will happen. There was a recent enforcement involving the pet cremation business, where there were some very broad non-competes, national in scope, applied to all of the employees of the sort of dominant company in the pet cremation space. So I think that's an example of where you can expect to see scrutiny, right? If your non-competes apply to everybody, to the janitor, to the up to the CEO, and they're national in scope and they last for a year, that may be something that is overbroad. But I think we're going to have to continue to see what the agencies do, and in terms of being able to give more specific advice.
Yeah, I agree.
Well, thanks everybody for joining us. Really appreciate Jeff for joining me. We had a good discussion, and we'll all stay tuned to more to come. I think we're just seeing the first inklings of what this is all going to look like going forward. Thank you, Jeff.
Yeah, my pleasure. Thank you, Herb. Have a good one.